So guys, our politicians don't want us to have a live broadcast, at the tribunal. They want everything to be done hidden. And Nigerians have raised their voices that they want the court to allow for a live broadcast so that people could watch what is happening in the courtroom, even from the comforts of their homes. And one keeps wondering, why are they not allowing for a live coverage of the court sessions? I think the APC and the CJN have to answer this question.
Where the trial wasn't televised at all, but eventually the verdict was televised. People could watch, and I'm sure a lot of Nigerians have the copies of the judgment, the video judgment on their phones. For you, I don't know if you've seen that particular judgment. Do you think that that's something that we could adopt? That perhaps all of the hearings and all of the nitty-gritty can be behind the cameras, but the eventual verdict, do you think that is something that will be worth televising in a manner as clear? Because I listened to that judgment. It wasn't. You could hear what areas of law the judge had relied upon and how he reached his verdict. Do you think it's something that Nigeria perhaps can adopt?
No, it's
Fellow Nigerians, do we really need 180 days for our judiciary to conclude on the petitions that are before them? Do they really need 180 days to deliver their verdict? Take a look at this.
But then the question I want to ask you is, within the ambit of the law given to the tribunal to deliver its judgment or to end its sitting, as the case will be, in 180 days, are there any ambiguities in the laws backing the electoral process that could cause a delay in the dispensation of this cases?
Yeah, thank you for having me. The truth of the matter is that when 180 days was prescribed by the Constitution for the hearing of the election petition at the Court of First Instance, we were still using the old Electoral Act, where issue of technology wasn't much deployed in the electoral process.
So guys, let me allow you watch this video. But before I do that, I want to plead with the Nigerian youths. We shouldn't make the mistake we made during the election, because the INEC chairman kept promising the Nigerian people that they are going to carry out their duties credibly, and the Nigerian people overbelieved them. And we all relaxed, not knowing that INEC had a plan B. So guys, as the court proceedings have started, please, all eyes should be on the judiciary. Let's keep mounting pressure on them to do the right thing, because we all know that we are not ready to take anything less from justice. They should dispense justice, and only justice should be dispensed. So guys, let me allow you watch this video for yourself. Just relax and listen to the ideas of these men on the channel. Please don't forget to subscribe to my channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others. And let me know what you think in the comment section below. Thank you.
Yeah. All right, let's see if we can bring in Dr. Obani here to look at that part of the law that you talked about. Dr. Obani, Mr. Wangu here has talked about the fact that every aspect of the electoral process is backed by law. And yesterday we heard the chairman of the tribunal advising the lawyers in the court and everybody there to avoid any technicalities or delays and ensure that there are no shenanigans, so to speak, to waste time. But then the question I want to ask you is, within the ambit of the law given to the tribunal to deliver its judgment or to end its sitting, as the case will be, in 180 days, are there any ambiguities in the laws backing the electoral process that could cause a delay in the dispensation of this cases?
Yeah, thank you for having me. The truth of the matter is that when 180 days was prescribed by the Constitution for the hearing of the election petition at the Court of First Instance, we were still using the old Electoral Act, where issue of technology wasn't much deployed in the electoral process. And so 180 days was used there. From the time of filing to the time of delivery of judgment is 180 days at the election tribunal. But now in 2022, you now have an Electoral Act that part of it has a lot of technology infused into it. The issue of beavers, making sure that those who actually participate in the electoral process are known. You cannot manufacture figures anymore. And then we have the issue of IREF, the result already loaded and everyone has seen it. And then you have this issue of having certified true copies of this election result from INEC. And then the new act is even reduce the number of witnesses you have to call, unlike in the previous act, where you have to involve all the political party agents from the polling unit in order to prove their case. Now, if you have the documents from INEC showing the result, it can be brought to the court, so to speak, and then admissibility of that document becomes a very veritable tool for you to prove your case. So the new act has even made it simpler, that we may not have to spend the 180 days, which is based upon the former act. But now the new act has reduced all those levels of processes that make it a bit cumbersome in proving your case as a petitioner. And so I think that the using 180 days was for a reason. Now that technology is being infused in our electoral system, we have to look at that particular constitutional provision once again in order to see what we can do to reduce the number of days within which to hear election petition. Now, if you are given 21 days within which to file, meaning there is a sense of urgency. So why are we now saying we have to take 180 days? And of course, in all other nations, people want to see a situation where the electoral process is concluded, the judicial process, which is part of the electoral process, being concluded before you swear in somebody who is alleged to have won the election. So I think there's going to be a tinkering with the law. 180 days, I don't see any problem with it. The new act has even made it simpler, for matters to be proved within a short time, rather than waiting for that 180 days within which to conclude the election petition.
All right, I think our colleagues in Lagos have questions for you.
Thank you, Nyota. Well, let me begin with you, Barrister Dr. Obani. And I'm pretty sure that Mr. Wangu would also want to weigh in on the same question. There are a lot of emotions attached to this particular process, particularly the Presidential Election Petitions Tribunal. There are those who are already saying they're not likely to get any justice. It's just going to be the same old, same old. With the emotions involved, with the number of petitions from different political parties, and with the high expectations of a sizable chunk of Nigerians from different divides and different political leanings, and the emotions invested already, Dr. Obani, what assurances can you give Nigerians? What do you think people should be looking out for that will make this, whatever the outcome is, just what Nigerians want, irrespective of their expectations? Well, Mr. Wagu, same question to you with the emotions involved and in this particular process and the expectations of a sizable number of people. Right? So Bani initially has said it's going to be application of laws, not application of emotions. But then, how easy will it be for us to dichotomize the two? Mr. Wagu, can you hear me?
Election is an event that is vehicled by emotions. People throw in different kinds of emotions into elections. But in terms of oversight, the responsibility of the people who oversight elections will be to look at the laws. We'll look at it from the lens of the law, from the lens of the regulations, from the lens of the Constitution. And it does not require emotions. What has happened and what we need to guide against, which is what I've continued to maintain, is that when you win election in your polling unit, does not mean that that election was won everywhere. And even when you win in a sizable way, it does not mean that the person has fulfilled all the conditions that the law stipulates to be able to be declared a winner. And so when you are declared a winner, it becomes the responsibility of the judiciary to say, yes, it is possible you scored this number of votes, it is possible, but did you fulfill for a presidential election, for instance? It is important. There is a reason why the Constitution, why the Electoral Act is very clear as to the spread that somebody who should be president should have. So even when you have won majority votes in a particular area, those who are oversighting this will look at the whole landscape. They will place it before them and then see whether you have fulfilled all of that. And the challenge is when we train in election observers and we tell them, look, you are observing in a particular polling unit. So when you are going to talk to the media, don't say, don't just make a call on what you saw in your polling unit, because that may not be representative of what has happened everywhere. And that is why we encourage political parties as well.
If you can hear me, Mr. Wagu, just one second. If you can hear me, my apologies. Just one second, Mr. Wagu, if you can hear me.
Present the party, get those results for
just
them.
A second, Mr. Wagu. My apologies, my sincere apologies for butting in. All of the things that you're saying are valid. I mean, it's been our history for the past 20 whatever years now. But this one in particular, this particular election, you would agree, you referenced it earlier when you began to talk to us this morning, that a lot of emotions have been invested, is being invested, and expectations are high, to the extent, as you also referenced earlier, that a number of people are saying, why must we have the swearing in before the tribunals have stopped seating? So essentially saying, that at the end of the day, what we want is justice, yes, but we expect it to go in a particular direction. And if it does not go in that direction, they may not feel that justice has been served. What should we be telling them now, so that whatever happens, it will be respect for the judiciary, particularly because this is how it ought to go based on the laws that govern the elections?
The first thing is for those who are engaged in public commentary to acquaint themselves with the relevant sections of the Electoral Act. And I'm always very excited when I come to channels and I see every person holding a copy of the Electoral Act. It gives me confidence that people are acquainted, relatively, albeit to the level of the ordinary person, even though there could be also lawyers. And remember that as you have 1,000 lawyers, 1,000 opinions on every matter. So it is to set up public imagination in a way that there are people who have been given this responsibility, and we should have confidence in them that they will be able to deliver what is right. In 2011, for instance, if you remember, the current president had been to court 3 times. In all of those 3 times, he's always said he won the election, that he won it, and public imagination around his own area, the truth was that he did win in a particular section of the country, but he could not go around the country and say, I won everywhere. So the judiciary interrogated it from the point in which he was losing. He was always saying that, the judiciary, but once he won in 2015, the judiciary is the last hope of the common man. So we need to interpret those things correctly, that the fact that you think you have won does not necessarily mean you have won. And that was why I made the point about winning in a polling unit. You can win your polling unit convincingly, but this country is huge. 176,000 polling units, 176,000 of them polling units scattered across the length and breadth of this country. So it is possible for you to win in Ifezin, but you may not win in Ikolekiti. And you must win round. And because now there is an oversight, all of this will be put on the table. The judiciary will put it on the table, everything, and then look at it collectively. When they have looked at the votes cast, they will now again look at the spread. If somebody fulfills those conditions, it may not go down well with you, but that is what the law is. It's like the 180 days we are discussing. What is the hurry? Why you must conclude it before? There's an expectation, and that expectation is running against what your idea of justice is, because you probably think the person who has been declared is not justice. and then you want it to be hastened. But we don't need to pander to that. We have to follow the process. It is the discretion of the judiciary to say we can do this in 180 days, we can do it in lesser, depending on the avalanche of evidence that is available to them. But one thing that is very clear is that hallucinations disappear when evidence emerges, and that is the core of what we need to put out. Once evidence emerges, all your hallucinations, everything you are thinking will disappear. So let's focus on what we know to be the law, the current law, not what we are thinking should be the law. The law is there already. It will be interpreted, and we hope that those who have been given that responsibility will discharge it according to the oath that they have sworn to the Constitution and to God Almighty as well.
But Mr. Wagu, just to this one question, and then my colleagues over there can take over. There is that call by some sections of the judiciary, people in the courts as well, for a live broadcast of the presidential election petition ongoing process. What's your take on that? Is it permitted, or is it for or against the law?
Well, really, I can't make a call on whether it's legal or not, but I'll just tell you a story. As a member of the 2014 National Conference, we did advocate for live telecasts of our sittings and sessions. And what that, in retrospect, what that did was that a lot of people started playing to the gallery. And we are not talking to the issues. They were now talking to the cameras. And that took away the real issue. So when we went into executive sessions that were closed, people spoke their real mind and what they know to be the truth. I will give you an example. On derivation, 50% to the Niger Delta, 50% to the oil producing. When they come to the sessions, they do it. So why were you saying that when you know that? They say, if I go home, my people are seeing me. So my sense is that as important as that level of transparency is, but we are dealing with very technical issues that can endanger a judge who perhaps stays on the course of the law and does not run on these emotions that we are talking about. Because when you do that, it will be a matter of you are now deciding whether what the judge, and this person does no understanding of the whole gamut of the law. I think we need to be circumspect in falling for that. I think that we should have confidence that those who have the responsibility. We've had very serious cases in the judiciary that are not live televised, and I think we should.
The trial of Senator Atiku in the UK, where the trial wasn't televised at all, but eventually the verdict was televised. People could watch, and I'm sure a lot of Nigerians have the copies of the judgment, the video of judgment on their phones. For you, I don't know if you've seen that particular judgment. Do you think that that's something that we could adopt? That perhaps all of the hearings and all of the nitty-gritty can be behind the cameras, but the eventual verdict, do you think that is something that will be worth televising in a manner as clear? Because I listened to that judgment. It wasn't. You could hear what areas of law the judge had relied upon and how he reached his verdict. Do you think it's something that Nigeria perhaps can adopt?
No, it happens. It's just that it is not put out there. The plaintiffs and the defendants have copies of the judgments naturally. That is why sometimes when they finish, they say they will give the judgment, and then later they will do that. So it's there. So if the call is that for the verdict to be televised, I don't have an issue with that. But the treadmill of judicial intervention should not be exposed to popular interpretations, because that will mean that you are going to evoke those emotions, and then it can actually not lead to the outcome that we're looking to.
All right, thank you so much. We've been speaking with Ezinwa Nwangu, Chairman, Partners for Electoral Reforms, and we had here in our
So guys, you have seen it for yourself that we all have to be up and doing. We shouldn't allow a repetition of what happened during the election. We shouldn't just go home and relax and leave the judiciary to do whatever they want to do. No. Fellow obedience, we all should be on our duty post. We have to pressurize the judges to ensure that justice and nothing less than justice is being dispensed, because we know that this election, we won this election. We won the presidential election. There is no two ways about it. All the votes that were stolen, all the votes, that they tipexed, they must account for it. I mean, INEC must account for it, meaning that Bola Tinubu must return his certificate of return, because we all know that he didn't win this election. So we shouldn't be intimidated by the APC. We shouldn't be intimidated by the money they have. We shouldn't be intimidated because they are in power. We shouldn't be intimidated because they have access and they control the judiciary. We shouldn't be intimidated by any of those things. Let's stand on our feet and demand for our rights and ensure that the justice and the judges and even the CJN, they stand with the Nigerian people, for justice must prevail. Please don't forget to subscribe to my channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others, and let me know what you think in the comment section below. Thank you.